Hello and welcome to ThinkTech Hawaii. Today we're going to have a continuation of an earlier conversation between me and my friend Rory Fowler from Canada. We're going to talk about military justice in North America, at least the northern two-thirds of North America, and some of the exciting and interesting things that have been going on in both countries.
Good evening, Gene, and thanks again for inviting me back and for our conversation, for carrying on our conversation from a couple of weeks ago. And I say good evening, and it's evening where we are. I suspect where this is being broadcast in Hawaii, it's still in the early afternoon. So good evening and afternoon.
It's great to be back with you, Rory. I should mention that the moderator for the Act One of this operetta, Dr. Ken Rogers, was unable to join us, but I want to thank Ken publicly for having moderated so well the first installment, and also to mention that the godfather of ThinkTech Hawaii, my dear brother Jay Fidell, is currently in Singapore and on his way back to the Sandwich Islands, which is to say the state of Hawaii, and ThinkTech Hawaii viewers will, of course, welcome him back, aloha shirt and all. So with that by way of introduction, I want to ask you a quick question, Rory. You're a...
Okay, it'll be a quick question, and with my track record, it won't be a quick answer, but there we go.
Well, you never know. You're a military justice maven for many years. What's your favorite military justice movie?
Oh, it's that takes me by surprise, because there are plenty of movies that I would characterize as not my favorite movies because they are so inaccurate. And right up there at the top. I mean, he puts 100% into every movie he makes. But Tom Cruise and A Few Good Men. And I mention that because a good friend of mine at law school, it was his favorite law or lawyer movie. And it's among my least favorite as far as a depiction of the law. It's entertaining, but it is so incorrect in so many ways. I would have to say, in a pinch, it's going to be the Caine Mutiny. And it's the reason for that is because for me, and I know different people have different views about who the hero of that movie is, but for me, the hero of the movie, not surprisingly, was the lawyer. So Jose Ferrer was phenomenal in that role, and it was realistic, and it depicts the morality of military law as much as the actual practice of the context. And that's why I really enjoy that movie. I mean, it was a superbly acted movie from everybody. But for me, the great thing about it is Ferrer was not the hero of the movie from a Hollywood perspective. But as far as I'm concerned, he was the hero of that movie.
Right. My favorite scene from the movie, which I've actually referred to once or twice in defending courts-martial, is the very last scene.
Absolutely.
The very last scene
mine as well
is where I think the lawyer, there's a big party at the hotel celebrating the collapse of Lieutenant Commander Queeg on the witness stand, and the acquittal and so forth. But he says, he has a long bit of praise for the regulars who were in service making a pittance, before World War II, who rose to the occasion after serving in great obscurity for the pre-war years, and then they all leave. And I've referred to this in argument on sentencing, unfortunately, for the proposition that after this trial, nobody's going to be celebrating. There won't be a party at the hotel. And I don't know how court-martial members have reacted when I've done this, but it seemed to make sense to me. Does it resonate for you?
It does, because he encapsulated the nature not just of military justice, but when you look at criminal justice or even non-criminal justice, when you're adjudicating difficult facts. At the end of the day, with so many of these cases, nobody actually wins. It's a question of mitigation of harm in so many ways. And for what it's worth, what I view that movie as representing is a triumph of the rule of law as opposed to a triumph of any one individual. And whenever the rule of law triumphs, there's going to be somebody who's going to get hurt. There's going to be somebody who's not going to be happy. And Ferrer's speech at the end really encapsulates the fact that morality in those sorts of circumstances is rarely, if ever, black and white. And certainly when I taught at Royal Military College, when I was teaching some basics of military law, there were certain movies that I used to convey certain concepts. Another one that I use is Breaker Morant, and Breaker Morant's an outstanding movie. And again, for me, the hero of that movie wasn't Breaker Morant. The hero of that movie was the defense counsel. But they are effective tools in conveying to future officers the nature of military justice and the fact that nothing is ever going to be black and white. And at the end of the day, it's a question of the quality of your judgment, and not just judgment of, a court martial, but an officer's judgment in determining the appropriate course of action. Because it's never going to be the ideal course of action or the absolute correct course of action. It's about adjudicating and determining the most efficient and the most meritorious course of action when you're choosing from among imperfect options.
Right. And, the thing that's always struck me about military justice, really from the very beginning of my involvement, was that even more than criminal proceedings in the civilian courts, in military justice, and I've both prosecuted and defended, in military justice, it's the individual on one side of the courtroom and the state on the other, which is always a fraught interaction. But it's heightened because of the elements of drama and ritual that are involved, peculiarly in a military courtroom. People wear costumes called uniforms. They have particular ways of interacting with one another. Rank is always, a factor. It's always in the courtroom. It's inevitable. So that to me has always meant the military justice was an easy target, not a target, but an easy subject to use as the fodder for a drama. Now, on the K Mutiny, let me be the first to use the time-honored phrase, I once had a case. I've been involved in a mutiny case. It was a racial episode in the early 70s, but I actually had a case once that involved strawberries. Or ice cream, or strawberry ice cream, right out of the K Mutiny. It wasn't a court martial, but it was one of those personnel issues that come up from time to time. But I wanted to say this: not to overstate it, but I had a passing acquaintance with Herman Wouk, and he was quite an old man when I met him. He must have been in his 80s. Which doesn't seem that old suddenly, but he was a person of great dignity, and his service in the U.S. Navy in World War II was obviously tremendously important to him. He was a junior officer. He served on a ship, and the name of the ship was the USS Zane. And that was, in fact, the model for the USS Kane. Now, how much of what he depicts, he was a non-lawyer, by the way, he wasn't a lawyer. How much of what is depicted in the Cane Mutiny, both the book and the play and movie. Who knows? But he obviously had a real sense of justice on the ground. So that's you've answered my question. Now you're going to ask me the same question. Are you?
No, because I think we already know the answer to that. I mean, unless you're going to tell.
What do you think it is? What do you think?
Well,
I think you're going to be wrong, my friend.
Okay. Well, then, Gene, to turn the tables on you, what is your favorite military? And I'll say this: not court-martial, but military law-oriented movie.
Absolutely. I thought you'd never ask. It's a Jack Nicholson movie called The Last Detail. Have you ever seen it?
I have indeed.
This was a fabulous movie in which Jack Nicholson is a sort of cigar-smoking bosun mate or master at arms whose job it is to convey a young man played by Randy Quaid from Norfolk, Virginia, up through Washington and Boston to Portsmouth, New Hampshire, where the U.S. naval brig was. And the young man in question was going to the brig for a few years for having stolen the contents of the charity box at the base chapel. And I think my favorite scene in the movie occurs in Washington. Nicholson and his fellow brig chaser take the young defendant to a bar near Union Station in Washington to buy him a beer. And they go in, and it must be wintertime, and they order 3 beers. And the bartender says, well, I need some ID for the kid. And Nicholson says, just give us the beer. And the bartender says, I told you I need some ID for the kid. And same thing happens again. Nicholson says, look, pal, just give us the beer. And the bartender says, look, buddy, if you don't get out of here right away, I'm going to call the shore patrol. Whereupon Nicholson opens his reefer, his little blue pea coat, pulls out the .45 that he's carrying, slams it on the table and says, and I'm going to sanitize this a little bit, hey, pal, we are the blankety blank shore patrol. And of course, the very last scene, and then we'll be done with this and we'll actually talk some law, but the very last scene of the movie, they finally get to Portsmouth, New Hampshire, to the brig, and there's a Marine first lieutenant as the watch officer, and they hand this kid over to the brig where he's going to be for a few years. And Nicholson, of course, there's paperwork involved, and Nicholson hands this shaved-tail lieutenant a set of orders, 7 or 8 copies of the orders. And the lieutenant takes them and he's looking down, and Nicholson and the lieutenant dismisses them. You can leave now. And Nicholson, who I think has a cold cigar stub in his mouth, says, say, Lieutenant, you're supposed to pull a copy of those orders. And that's the end of the movie. It tells it all. All right, let's talk military justice. So we talked in Act 1 of everything you ever wanted to know about military justice with Rory and Gene, about a range of topics. What's going on in Canada right now in terms of law reform?
Well, there's what I would characterize as the follow-on or the subsequent action following a variety of reviews, right? So we had a couple of recent reviews. One was ad hoc, and that was the review by former Supreme Court of Canada Justice Louise Arbour, and that was specifically about sexual misconduct. It was an ad hoc review. Certainly, not everybody was critical of it. I've had some critical things to say about it.
When you say ad hoc, you mean as opposed to one of the periodic schedules?
That's right.
Right.
It wasn't required under statute. It was simply convened by the minister using at the time because it was a different minister, statutory powers for the direction of the national defense and the armed forces, essentially commissioned a review led by former Supreme Court of Canada Justice Louise Arbour. And she examined aspects of sexual misconduct and the Canadian Forces' response to sexual misconduct. So that was an ad hoc review. More or less contemporaneous, although he began his review at a different time, and he concluded his review after Justice Arbour did. Former Supreme Court of Canada Justice Morris Fish was conducting a review that's required now every 7 years by virtue of Section 273.601 of the National Defense Act. So that used to be a review every 5 years. So the first two reviews were conducted, or were supposed to have been conducted, every 5 years. The second one was late. So the first review, and this dates back to 1998 with Bill C-25. The first review was done in 2003 by the late Chief Justice Antonio Lemaire, and the subsequent review was done by Associate Chief Justice of Ontario Patrick Lesage, and his review was a little bit late and not quite as beefy as that by the late Chief Justice Antonio Lemaire. And so the third review that was conducted by virtue of the National Defense Act was by Justice Fish. Now, there's a couple of differences. The first two reviews by Chief Justice Lemaire and Justice Lesage were technically limited to Bill C-25. They weren't reviews of the entire National Defense Act. Now, nothing barred them from being a review of the National Defense Act, but they generally focused only on those elements of Bill C-25, which was the last time we had significant reform until recently of the Code of Service Discipline under the National Defense Act. Justice Fish's review under Section 273.601 of the National Defense Act was a review of the entire National Defense Act. Now, there were certain things that they focused on. Clearly, Code of Service Discipline was one of the big items. Military policing was another item. The grievance process was another item. And that was required. So the minister was obliged under the National Defense Act to convene that review. At about the same time, or shortly after those reviews were conducted, we finally implemented significant portions of Bill C-77, which was first enacted in 2019. But many of the provisions did not come into force right away.
Right, that bill didn't get royal assent, or it wasn't implemented for a long time.
That's right. So it got royal assent in the summer of 2019, very shortly after it was enacted. But there were several provisions that would only come into force, which is the term used here, upon the enactment of certain regulations, including the so-called Victims' Bill of Rights, which was enacted to parallel the Victims' Bill of Rights in the civilian criminal justice system under the Criminal Code of Canada. Now, the reality is there's a great many things in the Victims' Bill of Rights that were already being done as a matter of policy, but were not being done because they were obligatory. And so on the 20th of June, 2022, significant portions of Bill C-77 finally came into force. And that happened shortly after Justice Arbour tabled her report or provided her report to the minister, and shortly after Justice Fish provided his to the minister.
Right. So what you have, I'm just, listening to your account, what you have is a kind of cascade of reforms so that the next stage of reform is already beginning maybe shortly after or even before the last stage has been digested by lawmakers and the management, which just as a friendly observer strikes me as highly inefficient and calculated to create training problems and compliance issues.
Yeah, that's a friendly way of putting it. Because the reality is there were significant reforms, and not the least of which, and for me, the implementation of the Victims' Bill of Rights, fair enough. But for me, the big thing was the introduction of a new summary justice system, which is markedly different than the one we had before, and in effect, completely separate now from our court-martial process. So before the 20th of June, 2022, we had a two-tiered military justice process with summary trials representing 95% of the trials relating to offenses under the Code of Service Discipline, and courts martial. And one of the saving graces of the summary justice system, which is conducted before people who aren't remotely independent, was the option in some cases to elect trial by court martial, although quite frankly, many in the chain of command would try and shoehorn offenses into 5 specific offenses for which there was no election for court martial. And we'll return to that in a second. As of the 20th of June, 2022, there are no longer summary trials, although there were some summary trials conducted after the 20th of June relating to allegations that predated that date. So any vestigial or vestiges of offenses that predate that time could be dealt with by summary trial. Although after a year, there won't be jurisdiction for those anymore.
Can a member of the Canadian Armed Forces say, Captain, I want to have a jury. I want to have this thing go to court. Not that I don't trust you. I just would rather have, this is a serious charge that you've laid against me here. I'd like to have a real trial. Can a member?
Not now. So before, under our summary trial process, if an individual was charged with an offense for which there was an election, the individual could elect trial before court-martial. Now, that opens up a broader scope of powers of punishment. But the reality is, if it's a low-level offense, the likelihood of a significant sentence, even if found guilty, isn't significant, and at least they get an independent trier of fact who actually understands the law.
But to some extent, you're rolling the dice. To some extent,
to an extent. Yeah. But if I were ever advising, and I have, if I were ever advising an individual, I would generally tell them, unless you're planning on pleading guilty or admitting to the particulars of the charge, your best bet is a trial by court martial. There was one matter actually before I became a lawyer when I was an assisting officer, back when I was an infantry officer. And it was so clear that the presiding officer was going to make a hash of it because he'd already made several mistakes. I had actually told the accused, who was a warrant officer, go with the summary trial because he's going to mess it up. Not exactly my words that I used, but and sure enough, the presiding officer made a cocked hat of it. It was just a dog's breakfast. Unfortunately, now
the cocked hat. I mean, the imagery is getting away from us here.
So now the challenge now is if somebody is facing an allegation that is going to be dealt with under the summary system, it's a completely separate system. So now we've got summary hearings, which are used to preside over allegations of infractions. These are non-penal offenses. And to a certain extent, it's word games. But if somebody is charged with a service infraction, there is no election for court-martial. It will only be dealt with by summary hearing. And the burden of proof is balance of probabilities, which, quite frankly, most members of the chain of command do not actually understand. They don't understand that. Yeah, go ahead, Gene.
Yeah, I just want to ask you a question. And by the way, I see the sands of time, the sands on the clock are running out. But very, very quickly, suppose you had a possession of marijuana charge. Could that be charged either summarily or in an honest-to-Pete court-martial?
It wouldn't be tried at all because marijuana is not prohibited in Canada now. Let's change it. So because it's still an intoxicant or a stupefacient, to be more precise.
Oh boy.
So there are still prohibitions, for instance, against smoking marijuana because it affects you. It's like alcohol.
Sure.
You can't smoke marijuana 8 hours or 12 hours before duty. So let's say somebody is charged with a service infraction for contravening the DAOD on marijuana, which, if memory serves, it's 9003-1. And they're charged with a service infraction for doing so. There's no election for court-martial. It won't give rise to a criminal offense. But here's the thing. This is what's particularly interesting. Nor does it create what my friends in the United States would call double jeopardy. Because they aren't offenses, if you are tried and prosecuted under the summary justice process, so a summary hearing, that doesn't bar subsequently being charged with a code of service discipline offense and tried at court-martial. And so it's conceivable under the current regime that if somebody was not happy with that outcome, they could then lay the charge as an offense pursuant to, for example, Section 129 of the National Defense Act, which Justice Fish was not massively enamored with in his independent review, and be tried at court-martial, notwithstanding that you were tried by a summary hearing for the service infraction. What's more, it's not yet fully resolved the extent to which you can rely on any testimony or any statements made in the conduct of the summary hearing.
Where no lawyers are involved, I imagine. Yes?
What's that?
Are there lawyers involved in summary proceedings?
Well, an individual can consult a lawyer, but there's no right to be represented by a lawyer. And quite frankly, most officers conducting summary hearings will refuse to permit somebody to have their lawyer present.
Yeah. Rory, I hate to say this, but our time is up. But this has been great. I think we have to do this again and again and again until we get it right. I want to thank you on behalf of ThinkTech Hawaii. The maitre d', Jay Fidell, will be back presently, and I'm sure we'll hear from him. I hope we get a good report and a high grade. If you like the show, tell Jay. Otherwise, best wishes to everybody for the holiday season and a nice, safe spring. Thanks very much, Rory. See you soon.
See you, John. See you, Eugene.
Thank you so much for watching ThinkTech Hawaii. If you like what we do, please like us and click the subscribe button on YouTube and the follow button on Vimeo. You can also follow us on Facebook, Instagram, and LinkedIn, and donate to us at thinktechhawaii.com. Mahalo.